Case 44, Olympic Airways versus Husain. We find ourselves at the Supreme Court of the United States. Facts. While Rubina Husain, hereinafter respondent, and her husband, Dr. Hansen, were traveling overseas, she requested that petitioner, Olympic Airways, provide seats away from the smoking section because Dr. Hansen had asthma and was sensitive to secondhand smoke. After boarding, they discovered that their seats were only 3 rows in front of the smoking section. A flight attendant refused respondents' 3 requests to move Dr. Hansen. As the smoking noticeably increased, Dr. Hansen walked towards the front of the plane to get fresher air. He then received medical attention but died. Respondents filed a wrongful death suit in state court, which was removed to federal court. The district court found petitioner liable for Dr. Hansen's death, and the Ninth Circuit affirmed, concluding that under Sachs' definition of accident, the flight attendant's refusal to reseat Dr. Hansen was clearly external to him and unexpected and unusual in light of industry standards, Olympic policy, and the simple nature of the requested accommodation. So what's the issue? Whether the conduct here constitutes an accident under Article 17. Holding. The court held that the conduct here indeed constitutes an accident under Article 17. Reasoning. Under Article 17 of the Warsaw Convention, a carrier's unusual and unexpected refusal to assist a passenger, such as refusing to move an asthmatic away from smokers, meets the accident condition precedent to air carrier liability. The carrier's action is a link in the chain of causation resulting in the passenger's pre-existing medical condition being aggravated by exposure to a normal condition in the aircraft cabin. Because liability can be imposed for death or bodily injury only in the case of an Article 17 accident, and Article 25 only lifts the caps once liability has been found, these provisions read together, tend to show that inaction can give rise to liability. Moreover, Article 20 makes clear that the due care defense is unavailable when a carrier has failed to take all necessary measures to avoid the damage. These provisions suggest that an air carrier's inaction can be the basis for liability, according to the court's majority.